Thursday, March 30th, 2023. Policy Procedure Committee. Call the roll, please, Amanda.
Barons.
Here.
Alt.
Here.
Awful. Here. Sure.
Here. We need a motion to approve the agenda.
So moved.
Is there a second?
Second.
All in favor, say aye. Agenda approved. Do we have any public comments this morning? Seeing none. We'll go to the committee chair reports. Begin with Mr. Barnes on the management committee and the judicial committee. Or no, you're not judicial. Mine isn't working yet this morning,
Management,
whatever it does.
if we get bids in, we sent out for 3 different bids and so far nothing's come in, so hopefully we'll get something by the meeting.
Depending on what?
Fertilizer,
Oh, okay.
Garbage, and gas.
Oh, 3 different things.
Yeah.
We have fertilizer.
I thought you meant
You
3
did get
different
some? Okay.
bids on one thing.
The gas come through the same guy that gives us the electric? Or is that different?
He can. He has provided us pricing before, but I haven't heard anything from him.
Gas prices are up too.
Yeah.
Okay, well,
Other than that, we'll probably talk about the morgue if there's any updates on that, and just regular.
we have a meeting scheduled right after this, I do, with the coroner and Mr. Geiger to discuss some ideas.
Refrigerated semi-trailer? A refrigerated semi-trailer?
Something like that. That is if we can park it at your place.
Well, that would be very inconvenient for him, but I don't care.
Okay, Mrs. Awful, Health Committee.
Yes, we'll have our regular reports along with animal control.
Okey-doke. Mr. Alt, Highway.
We're gonna have an opening bid for one of the townships that didn't get bids on the bidding day. And, I think that's about all, except I hope Joel is in attendance, he's been coming back a few days now and then. And, be good to see him, otherwise we have the regular claims and that'll be probably it.
As a matter of fact, I spoke with Joel yesterday, a couple of days ago, last Friday, I think, when he sounds a lot better.
Last time I saw him, it looked pretty good, but I think he's doing all right.
Good. I'm gonna have lunch with him tomorrow, so I'll find out.
That'll break him.
Okay. Moving on, I will bypass chairman comments and go to Mr. EMA, Mr. Sacy.
It's been a while since I've given you guys paperwork, and I thought that was too easy on you, so I brought a couple packets. So in review, while I'm passing this out, I'll speak on things that are not related to this. I've talked to you all about having a cybersecurity briefing, cybersecurity. Yeah, you get one. Talked to you all before about having a cybersecurity assessment done by CISA. We started that process. I had a meeting with them weeks ago, where they basically did an interview with me, asked a bunch of questions, and now I got some paperwork to fill out. Once again, this is a cybersecurity assessment done by a federal agency, and it's at no cost to us. And I'll continue to work with Ms. Johnson and any other department head that is looking to participate in that. So that is still ongoing. The hazard mitigation grant, I received a grant agreement, so we're gonna get that signed and then sent back to the state. Once they give me a grant execution, that's when I can finally send out or publish a request for a proposal. So that's where I'm at with that. Accreditation. A couple months back, I talked to y'all about how the state was considering updating accreditation requirements. I attended a webinar with IEMA, and they talked to us local EMAs about changing a number of requirements. They were just kind of in the discussion phase of it. And they still are, but they have proceeded to the next step where they have decided, they haven't told us exactly what they're looking to change, but they're starting to get things a little more solidified, and this will probably take place over the course of the next 2 years. So it's nothing gonna happen right now. But, so they can make the changes they wanna make, which like I said, I'm not quite sure what they are changing the accreditation cycle for EMAs. Just from review, EMA is accredited, and by being accredited, we are eligible for grant funds, which is vital. So, we need to maintain accreditation. The main implication of the accreditation change of cycles means I do not have an EOP or emergency operations plan due on the 15th of this month. It was going to be due, but they want to implement changes and new requirements to the emergency operations plan. I'm not quite sure what those are going to be. We have some ideas, but in order to give themselves time to make new requirements from the EOP, they're changing the accreditation cycle, which is fine. New requirements of the EOP happen every few years, and it's fine. It's what we're here to do. It just depends on what those requirements are. So the next time an EOP is due from Iroquois County EMA will be 30th of June in 2025, I believe. In the meantime, I still had 2 documents due to the state. One was the ILCAT, or Illinois Capability Assessment, and thyroid tool. Basically, that is an assessment of our hazards and our vulnerabilities. What kind of hazards we have that exist in Iroquois County, and what impacts us more or less, and how we sit with each hazard. So, as an example, flooding is one hazard, and we are vulnerable to it, but we have lots of experience in it, so all these things are assessed. Or perhaps hazardous material incidents. Those we have in Iroquois County, we don't have a lot of capability to deal with, but we have mutual aid resources that we work with and practice with. So it's a large document that's basically assessing all that. That got turned in a couple months ago, but also turned in on the 15th of March was our Illinois Integrated Preparedness Plan from Training and Exercise Plan. And that's what you have before you. So, in short, this gives an overview of our most pertinent threats and hazards on the front page, according to the ILCAT, which I previously talked about. And don't worry, I'll print off the ILCAT and burden with you all of that later, but I didn't want to burden it too much. At the bottom of the page, you see core capabilities. That is some of the core capabilities that we really need to kind of try to proceed with, practicing and so on and so forth. If you look throughout the plan, you see where I've published things that I want to work on, whether it is new plans or revisions of plans on page 2. On page 3, you see different seminars or workshops that EMA is looking to try to host or get hosted locally to try to train with our local partners. On page 4 and 5 is exercises. Now this is a multi-year plan. So we do this regularly. This is a brand new format for us. This is something we usually do once a year. New requirements are going to make us start doing this twice a year, which is fine. It's just updating the multi-year plan as we go along. But in short, these are the kinds of things that we're looking at doing. Exercises usually gets the most attention. You can't just jump into an exercise before you have plans written or before you have trainings, but because it gets the most attention, let's give it the most attention. You see in August, I want to have an explosives attack, try to work that with local schools. Cybers, I want to have a cybersecurity tabletop exercise in September. June of this year, I want to have an active shooter drill. I've talked about that with the sheriff before and a couple other local entities. just locally hosted drills. So on and so forth. So I don't wanna waste your time by listing everything. But this is one of the required documents I wanted you to have a copy. With that, does anybody have any questions for me? Kind of see what I'll be working on for the next few months. Yes, sir.
Your business about a cyber attack, is that something that should involve our IT committee and other people, fellow from area wide?
It should involve area-wide. I'm more than happy to involve the finance IT committee. Because the IT committee has been merged with the finance committee, correct, Chairman?
That's correct.
Yes. A number of months ago, when I started the process with CISA, I first got a consensus from the finance committee. And I will continue to do that as I proceed with trainings and exercises for that subject.
It's just, I think that they're familiar with it, and also if things come out of that might require additional expenditures or whatever, changes on our part, then
Which department did you mention?
IT committee, finance IT committee.
What, 911?
Oh, don't worry, I bother him plenty. He's involved, whether he likes it or not.
Okay.
Yes.
I've already asked to be a part of this study. I wanted to do it initially when the state was actually offering this out, but I had far too much on my plate. But since Mr. Stacy is wanting to go there, I can definitely add into that capacity at a far better value. The whole study is going to be something that, well, yes, the finance committee should be involved in case there are expenditures. Initially, the study is going to be exactly that. It's going to be something for informational value, and then once Mr. Stacy receives the report / the county, you can make decisions after that.
Precisely.
I'm sure that probably all of our department heads to some extent, depending on how extensive this is gonna be, need to be aware of or about.
Part of what we're doing through SISTA is kind of a rolling continuous thing. They'll continue to do assessments. What I expect is they will find problems, because that's what they're there for. And any problems they do find will be brought to the county board's attention. Yes, sir.
You expect to have problems here in Iroquois County?
I expect to have problems no matter where it goes. It's as if they follow me around.
What's meant by community resilience?
Community resilience is a core capability. Community resilience can be broadly defined as how prepared or how ready is a community to deal with said type of disaster incident. So to sort of contextualize that, how resilient is the city of Watseka to flooding as opposed to the village of Woodland? Or as opposed to a place that is not used to flooding, village of Beaverville. The city of Watseka is more susceptible to flooding, but you could say from experience, they have in certain capacities more resilience because they know how to operate. Whereas opposed to the village of Beaverville, doesn't flood. So if they were to flood due to an incident like 10 inches of rain in a day, like what happened in Gibson City a couple of years ago, they would have less resiliency and less preparedness on how to deal with that specific hazard, because it's not something they ever thought they'd be susceptible to. In broad, that's what that means. Thank you for that question. That means that you're actually reading the document. I really appreciate that.
You got the Iroquois County Sheriff's Department on the active shooter.
Yes, sir.
Seems like you have an administrator of every school in the county in that.
Well, whatever seminar, when it comes to active shooter seminars, schools have already received a lot of those seminars and those trainings, specifically from the sheriff's department. So when we have future active shooter seminars, we're actually looking to target places of faith and businesses, because we've already talked to schools about it and they've already had the training. So very valid, and they're already ahead.
Okay, thank you. Before you run away, I'd like to make the committee aware that your situation may be changing, that Eric is transitioning into the position formerly held by Ms. Shippard with the Health Department. So I've had meetings with Dr. Zumwalt, who's the president of the Board of Health now, and Eric to try and formulate some plans so that there'll be more information coming forward on that in the near future, but in case anybody has concerns as to what's going on, that's the direction things appear to be heading, and more to come. So,
Two questions for you.
Yes, sir.
The ARPA committee gave a large sum of money to the fire departments for a centrally located building in Iroquois County.
Yes, sir.
They have a training room now,
Yes, I do. With
What's
3
the
large
oppor-
screens.
which is an opportunity for maybe you to get with them to do a centrally located seminar.
Already scheduled 2 trainings at that building last night, actually, but they're public health related, so I'm
Okay.
including my report. So yes, you're absolutely right. I'm really excited to use and abuse that facility.
Hopefully they'll let us work together with them.
They're excited for it to be utilized.
Good. The second thing is for the grant writing for what your next role may be.
Mhm.
Have you had an opportunity to put that out to get somebody hired to start doing that, since we don't have anybody do grant writing? And that's a big thing for,
Grant writing for, you say my next role, being in
yes,
public health.
yes.
So on and so forth. Before the Board of Health, I don't wanna put the cart before the horse before the Board of Health finally makes their final decision. Cause the Board of Health needs to enter into a contract with whomever the next administrator is. And before that's signed, I don't wanna put the cart before the horse. As it comes to grant writing, I'm already, as the interim administrator for the health department, I'm already doing a lot of the grant writing. I did one last week, and it's actually come spring, so we got a lot more regular grants that I gotta rewrite. When it comes to EMA, right now, we only have 1 grant with the hazard mitigation grant application. That's 2. I'm gonna stay on top of that with the transition plan as
So are they looking for somebody to fill that position,
to fill the grant writing position or the
Yes.
EMA position?
the grant writing position?
We're not looking for someone to fill the grant writing position.
Shepherd always did that.
So every position right now is full?
No, at the public health department, we actually have 2 openings. Our financial officer, position is opening, but I've already interviewed a number of applicants, we'll be making a decision about that by the end of the week. And we have an opening in senior services.
Okay.
But those aren't specifically grant writing positions. The administrator typically has been responsible for grant writing in the health department.
All right, thank you.
Any other
Got a
questions?
good one to teach him.
Okay, we'll move on to an update on the sexual harassment training.
Well, we're currently at 75% completion. We did send out notifications with payroll, the last payroll we had. I just sent out an email notification again, but I will send one out again, either the end of this week or beginning of next week. Most of the people that have not completed it are part-timers, so.
Well, 75% is a big jump from where we were last month.
Yeah, the payroll mailings were, a great suggestion. And I think going forward, we'll do that again, because a lot of the employees just took it upon themselves and got it done and bypassed trying to do some sort of setup with department heads or group trainings, they just did it themselves and trained it, so.
Hopefully, people will begin to realize it's something we have to do every year, and they'll just take it that, first part of the year to get it done and get it out of the way.
Yeah, I think they get tired of hearing from me,
You get tired of doing it.
it's not that bad.
Gotta keep
It's
it
just
up.
my man.
Okay, that being said, we'll move on to the discussion and action on our county personnel manual. I think we're at the point where all of these, everybody got a bunch of these policy changes last month. And I presume everybody has spent a number of days studying them and getting familiar with them, so that we can have a good discussion. Maybe the best way to approach it would be for you to kind of lead the way, Joe, and next Roland.
Sure. Not at all. Let's see here. I guess I'll just go down the road here. The first sample policy they sent us was, the model guarantee warning. Basically says here, and if it helps, Charlie, I got paper copies too, so I'm just fine. So it basically says here, there's the name of the employee, who it was administered by, and the date. And it says, I am writing to advise you that you are being questioned as part of an official investigation by Iroquois County. You will be asked questions specifically directed and narrowly related to the performance of your official duties or fitness for office. You are entitled to all the rights and privileges guaranteed by the laws and Constitution of this state and the Constitution of the United States, including the right not to be compelled to incriminate yourself. I further advise you that if you refuse to testify or to answer questions relating to the performance of your official duties or fitness for duty, you will be subject to discipline, which would result in your termination from the county. If you do answer, neither your statements nor your information or evidence which is gained by reason of such statements can be used against you in a subsequent criminal proceeding. However, these statements may be used against you in subsequent discipline action. And then there's a signature of the employee as well as the individual administering the warning. This is recommended to add into our policy. So I just need to know if the committee would like to add something in like this to our policy.
I'm trying to find out where you're at here because I haven't gotten there.
I don't see it.
Anybody have any problems with that? We've never had anything like this before. The only question that I had about it or wondered is, this is something that our state's attorney should have an opinion on?
I guess my biggest concern is, you're saying if they answer questions that can't be used in legal, what if they say, yeah, I took $100,000 of the county's money? And then they've admitted to it, but you can't use that against them in a court of law.
No, but they can be used against them in discipline.
But that, if somebody does something like that, is that enough?
That's where I'm wondering if the state's attorney might have a view or opinion on something like this. Supposedly this has been prepared by this gal who's a lawyer. You would think that that would have been taken into account, but there's certainly no guarantee.
Well, yeah, I mean, corporate lawyer versus criminal lawyer is gonna have a different opinion on things.
Do you wanna have Mr.
I
Ryan take a look at this?
I would.
Okay. Everybody agree to that?
Yes.
Okay, why don't we set that one in a separate pile here, because we may have others that we wanna do the same thing with. Move on to the next one, because we got quite a few to go through here.
Okay. The next one is the attendance policy. And let's see here. It's not gonna open. Alright. So, the attendance policy. Yeah, okay. Alright, looks like this last one, little paragraph. So the attendance policy says regular and consistent attendance by all employees is critical to the operation of Iroquois County. Attendance during scheduled work hours is an essential aspect of every position at Iroquois County. Employees are expected to be present and ready to begin their work at their workstation at the scheduled start of their shift and expected to diligently perform their work duties through the end of their shift except during scheduled breaks or lunch periods. An employee who exhibits unsatisfactory attendance or repeated tardiness may be subject to discipline up to and including termination. Employees are expected to call their supervisors at least 1 hour prior to the start of their shift or as soon as possible in case of emergency. If they will be absent or late for work, advising the supervisor of the reason for the absence or late arrival, and in case of a late arrival, advising when the employee expects to arrive at work. Failure to properly report an absence or late arrival in accordance with this policy may result in disciplinary action up to and including termination. This I don't think we need because we pretty much have this already in our handbook, but that's up to you guys.
You have it where?
We already have this in our handbook,
Okay,
so, I mean, we've already went through that, it's just a sample policy she provided. But again, that's up to the committee if you guys want to adopt some of it, all of it.
the only comment that I have about it is that it addresses something that has come up recently with one of the employees when they terminated and gave their parting remarks. I thought that it was a problem if they left a few minutes early and somebody called them on it, or if they came to work a few minutes late. This policy seems to address that issue pretty clearly, that it's not what we expected from employees. So I'm wondering on that basis if there's a reason or a need to have it clearly spelled out. Mr. Raymond?
Whatever her policy you adopt, that particular paragraph does not describe what abuse is or how you define abuse. So that definitely needs to be added in there, because without, if you use some type of limiter where it's a gray area and you don't have abuse described in black and white, you're gonna run into a lot of problems. And I'm gonna tell you, as a manager, I'm gonna run into a lot of problems when I try to performance manage somebody. Because right now our current policy says 6 misses inside of 6 months. And that does not describe anything other than it says abuse. So if we're gonna use relative terms, that's a huge problem.
You're talking about the penalties for abuse?
Not the penalties. What is abuse according to the policy? And if we don't have something in black and white there.
What do you think is wrong with the statement that says you're expected to be present, ready to begin work at the scheduled start of your shift?
That defines
And again, our
when it
policy
is.
already states that you are expected to be at work on your scheduled days. Excessive absenteeism, excessive unexcused absences, and pattern absences will lead to disciplinary action up to and including termination. Again, with policies, you don't wanna get so specific to the point where you follow them to the line. It needs to have some sort of discretion up to the department head. As to how to define such things as an excessive absence or pattern of abuse in your own department.
Well, that's what this policy states. It says
And that's what our current,
an employee who exhibits unsatisfactory attendance or repeated tardiness may be subject to discipline.
And that's what I'm
Doesn't say
saying
they shall
is-
be subject.
I don't think we need it, cause our policy already says that. So you added this in, you're basically adding in a duplicate copy of what our policy already says.
No, as long as it's covered clearly for everybody, that's acceptable to me, but as I said, we've had one employee, when they left here, was complaining about. They didn't think it was fair that they were called out for being a couple minutes late or leaving a couple minutes early.
Well, life's not fair. Can't please them all.
I understand that, but if we have it clearly stated,
I don't care either way, if you would like to add in a separate attendance policy, we can, but it's basically saying what ours already says.
okay,
So that's up to the committee, if you guys wanna add it in, you just gotta tell me.
What exactly I'd say in the current.
On the current one,
leave it out, right?
Here's the current one.
Right now, we'll go with what we have.
yeah, the current policy states employees are to report to work on their scheduled days. Excessive absenteeism, excessive unexcused absences, and pattern absences will lead to disciplinary action up to and including termination. Excessive absence, 3 occurrences of absence in a 30-day period or 6 occurrences of absence in a 6-month period is considered excessive. The time periods of 30 days and 6 months begin with the first occurrence of absence either will be cause for a step in the disciplinary action policy. Any evidence of pattern of use will subject the employee to disciplinary action policy. A pattern absence is an absence on the same day of the week, after and or before a weekend or holiday, or absence for the same reason will be considered a pattern absence. Employees who are suspected of abusing sick leave may be required to provide a signed verification of the reason for absence from their healthcare provider. Do you want me to keep going? Because we also include excessive absence caused by health, no call, no show, failing to call, we define what an occurrence is. And then there's also the responsibility and procedures that I can read if you want me to, but.
I think from what you, if I remember correctly, the objection on the part of the lady that did this was that I did identify how many absences would be reason for this and so forth.
I don't think we need this at all.
I don't know what
I
specific
thought there
employee
was, I
complaint
thought
you
there
were
was a
talking
comment to
about.
that effect. Doesn't matter, let's leave it the way it is and let's go to the next one.
I don't think we need it.
Okay, so,
Gary said it plainly there.
put that one in that file over there. Let's see, what do we got next? We have handbook acknowledgement.
What is
We
it?
already have this in our policy.
Which one?
Amanda and I adapted, it looks like this right here. Amanda and I adapted this when we do orientation, and we let them know that there is a policy employee handbook available in each office. We show them the handbook and we ask them if they would like a digital or paper copy, or they can request it from the department head at any time. But the sample policy they provided states, I have read, reviewed, and understand the regulations of policy stated in the employment policy manual and will comply with the policies contained in the manual. I understand that this policy manual is not a contract for employment, and that unless I am subject to a collective bargaining agreement or a separate duly executed employment contract, providing otherwise, I am an at-will employee, which means that my employment may be terminated at any time without cause or notice by either Iroquois County or me.
You say we already have this.
We started doing this,
We don't need this.
a couple years ago, so, I would like to change ours and add in that, the last sentence there that states, because we don't currently have that in there, that they understand this policy manual is not a contract for employment, and that unless I am subject to a collective bargaining agreement or a separate duly executed employment contract providing otherwise, I am an at-will employee, which means that my employment may be terminated anytime without cause or notice by either Iroquois County or me. So I would like to add in that sentence to what we have.
Sounds good.
Alright, next one is internet email policy.
Or is that just the? Oh, okay. I missed
There
the
we
first
go.
part, I just got the last one.
Alright, it looks like this, it's a couple pages long, hopefully you guys have read it, cause I don't really wanna read it.
Oh, come on.
But I will. This policy here is a technology resources policy, but it goes through that we provide employees with access to technology resources, gives examples such as telephones, cell phones, voicemail, text messaging, software, laptops, computers, just examples of what sort of technology we have. There's no expectation of privacy or assurance of confidentiality. The employer reserves the right to search these devices. Employees need to make sure that they comply with any reasonable requests from law enforcement or regulatory agencies. They must take care of and understand federal and state copy law. We already have something like this in place, computer use policy that we have them sign at orientation. So it just,
I had a couple of issues with
Sure.
this, so if we have them covered in our current one, I'm fine with it, but I don't agree with allowing the employees to use them for personal use.
we don't, in our current policy, it says
Which
you
it
cannot
says
use
in
it.
the middle of the first paragraph here that they can do that.
That's why I don't like their sample policy, I'd much prefer the one we already have.
And then on the third page in this paragraph, it pretty much says the same thing again. It says about how they could use the technology resources for non-business research outside work hours.
That's not
I
necessary.
don't think that's appropriate.
Yeah.
I thought I had a question about, you said somewhere about searching. I don't have a mind here.
Our current policy, it doesn't, I'm trying to find where it says it at. Yeah, it doesn't encourage any sort of personal use on these computers. It goes through, changing your password, not giving your password away, use your account, the ICB network is just for email work purposes only, no social media, no purchasing of personal items, no use of profanity, obscenity language. So I like our policy better, that's just my opinion, but you guys,
As long as we don't allow personal use, I'm good with it. I don't think we've ever had any employee or situation where it was either necessary or whatever that they use it for personal purposes, so. In fact, most of them, well, they could do it at work, I suppose, but most of them obviously don't have it at home. Mr. Raymond?
You obviously have a social media policy, some of this could touch into this. I haven't read this entire document, but how much of that wraps up into your social media policy as it is today? That could
We'll
interfere
get to the
depending on what
social
language you
media
have.
policy in a minute.
okay, if you're ready, the next one is limitation on the use of conviction records and employment decisions. So this is about Public Act 101-0656, which was signed on March 30th, 2021. Governor Pritzker signed this act into law, amending the Illinois Human Rights Act and limits an employer's ability to use a criminal conviction as a basis to take adverse action against an applicant or an employee. The law does permit an employer to consider an applicant or employee's conviction record of otherwise authorized by law, in quotations. It also permits an employer to take adverse action on the basis of the criminal record if there is a substantial relationship between the criminal offense and the employment position of the employing the individual would involve an unreasonable risk to safety or property. So
I think if this is something that describes what the law requires or permits, we can't argue with it, can we? On the one hand, it says you can't, and then it says on the other hand, you can, so just. It's obvious to me that anytime you're particularly considering hiring somebody, that's one of the things that you consider. That's why you do a background check. So this is something we want to adopt then, is that correct?
If you would like to, we can.
Over there.
Okay.
What's the next one?
Alright, the next one, model ordinance for travel expenses, I think we kind of did this already.
We just
Yeah.
adopted one.
Yeah.
Yeah, so that one we can just. That I like, we can just go right over that one. Alright, motor vehicle record check policy. So this is authorized drivers and motor vehicle record MVR check policy and procedure. The introduction states that the purpose of this policy is to ensure the safety of those individuals who drive Iroquois County vehicles or personal vehicles on Iroquois County business to ensure the safety of their passengers and the public. So it goes through policy statements, requirements to become an authorized driver, driver responsibilities. It also gives a listing of conduct resulting in traffic convictions that may result in rescinding an offer of an employment, terminating driver privileges or other disciplinary action up to and including termination, such as reckless or negligent driving, driving while impaired, illegal drugs, homicide, fleeing, driving without a license, hit and run, using a motor vehicle for a commission of a felony, operating a motor vehicle without owner authority, speeding at fault, accident, any moving violation, and then it gives an acknowledgement form along with it for the person to sign.
I don't believe that we have ever followed anything even close to this. I'm not sure that we would even want to undertake this. It says here about running every 6 months, running a review of every person's driving record. We've never done anything of that sort.
How many people actually
Yeah.
have county vehicles? I mean,
Sheriff's Department, the EMA.
What about the highway department?
Oh, and the highway department, but I think that they have to go through their own inspections and checks with IDOT. I don't know how often, but
The other question that I had is on the second page where there's a long list of all the things that if you were convicted of doing. How does that relate to what we just looked at a minute ago about your conviction records and whether you consider them with employment? And then on top of that, I wonder, when it talks about somebody being convicted, when are you convicted? Are you convicted when a jury or a judge finds you guilty? Are you convicted if you plead guilty? Are you convicted if you plead no contest?
Probably all three.
The only
We've had,
questionable one on that is if you plead no contest, because usually that's considered not an admission of guilt.
well, we had one instance with an individual a few years back that was a controversial one. And that individual had been charged with an offense and pled guilty, and it was stated that that person had not been convicted. So they were not affected,
No. If you plead guilty, then the
I'm
trial.
talking about information given to me from our state's attorney.
Well, but if you plead guilty, then the trial would go through and the judge would have to verify the guilty sentence, which would be a conviction, I would think.
This individual pled guilty to the charge and not on that individual's record. Guilty. I mean, I'm just, bringing it up more for the purposes of this policy here, not debating the right or wrong of what happened with that individual or others, but I'm just wondering if it's a good idea to have all these different things listed here and
Well, what is our policy now?
Don't do dumb stuff.
Okay.
I don't know, I have to look it up.
I was waiting for that.
We're gonna say what is dumb
Let
stuff.
me look, hang on.
We're running low on applicants.
Yeah.
So we have
That's what it
policy
means, right?
10. Oh my goodness. Policy 1061 is our use of Iroquois County owned vehicle policy. And basically the purpose, the same policy. So given a vehicles, owned vehicles are to be driven by employees who are specifically authorized to do so, or any employee who is authorized to drive an Iroquois County owned vehicle and who engages in unauthorized use of the vehicle will be subject to disciplinary action up to including vehicles are for business use only and not for use of personal. Employees will be allowed to utilize Iroquois County vehicles or equipment with prior approval from a department head or supervisor. There's responsibility of all authorized drivers to obey all traffic laws, including wearing seatbelts at all times. Iroquois County owned vehicles will be non-smoking, and the procedure is for any request for permission to use Iroquois County vehicles or equipment will be submitted in writing and approved by the employee's department head or supervisor. So it doesn't specifically list out, hey, don't do this, this, or this, it just says follow the law.
Do we think it needs changing?
well, like I said, as far as this goes, this business about checking on everybody every 6 months, I don't think that's doable.
If it's covered already,
Say leave it
Well,
alone.
I like ours better because it says
The other
follow the law.
part, listing
Instead of
all
listing
these,
all that and following up on 6
all
months,
these
you're gonna be
different
more
offenses,
liable if
I
you
mean.
don't do it, and honestly, who's gonna do it?
I say leave it alone.
leave the one we have alone, good idea.
Okay, so the next policy is the nursing mother policy. Again, I don't think we need this because we already have it covered in our policy. The sample policy basically says that we will provide reasonable paid break time and the break time may run concurrently with any of your break times already provided, and that a private room other than a restroom will be made available to the employee for their use, and we have this already in our policy.
We have the rooms?
Huh?
We have the rooms?
there is one over in the courthouse.
But not here or at
They have to
the
go all the
Did
way
you
to
ever
the
finish the
courthouse.
management? We were doing down at the West End.
I need one here.
I thought we were going to have one here.
I thought there
Yeah, I
was
thought we were
discussion
supposed to do
on
it,
whether
yeah.
we needed one here or not, and it was decided it was just at the courthouse.
We talked about doing it at the West End, we were
What
taking
was
out all the
that? I don't
stuff.
remember.
I think
Specifically.
when we were discussing it, if I remember
In the
correctly,
management committee.
it was required to be at the courthouse and or jail,
Yeah.
but not required here, and so at that time,
Okay.
we did not do it.
That's what I remember that. I didn't clearly remember that discussion.
if we're not planning on doing it, we should not have it in our policy then.
Well, here's my question. Julie is getting ready to have a child.
I thought we,
She's gonna take Bob's position. Do we want her running all the way to the
Not
courthouse?
really.
You gotta back
Danielle,
up
thank you.
Danielle.
Thank you, sorry.
No, I agree. I don't think she needs to go all the way over to the
I think
courthouse.
that's excessive.
it only makes sense to have one here.
Right.
Yeah.
Well, we do have 2 rooms that could be utilized that we put in over there.
Do they have to have a sink? That's what I thought that was one of the
I thought that was one
requirements.
of them. It doesn't say it in here, but I thought that was one of them. But there is a sink.
So they've changed it now, you have to have a sink in there because.
No, that was always a requirement because
They
they have to be able
wash
to,
up.
yeah, they need to be able to wash up.
Because I'm able to have them at Worth, be able to use a room and then come out of that room and they're able to go to the bathroom and clean up if they need to. I'm just stating what I have to follow for state Illinois law, so that's what I'm
Well,
trying
we need to decide if we're gonna do it or not gonna do it, I think, because.
We
if
already
we're not
have a
gonna do it, it
policy in
shouldn't
place
be
for
in the
this, I don't
policy.
think you need to
Is there
adopt
a,
that one.
is it the old kitchenette, is that,
to. Yes,
that can just be designated as, and a chair put in there?
What are you gonna do about that at the highway department?
There's
That would be
several
up to him.
restrooms out there open.
Yeah, there's
So it has to be
several
something
rooms,
other
not
than a restroom.
Yeah,
Has to be something.
but they
other
have
than-
other rooms that they could use out
Well, we
there.
got the back room, there's a sink out in the shop.
Okay, we're missing the point, we don't need
no,
this
we don't need
policy
it, I agree.
because we already have one.
Right.
So, and we've already
Maybe we
discussed,
don't-
we've already discussed our policy and made any changes that you guys wanted to make, so I
So
think
if
we're getting
there's
off
any-
track.
If there's any thing that needs to be designated, that can go to the management committee to designate.
Right. Put it on your.
What's the next one?
Again, it's one of those, if you have an issue, talk to your department head. Okay, let's see here, bereavement leave. Bereavement. So. Alright, so we already have a leave of absence bereavement policy 1029.
Joe, the question is, in the dark,
It's the
the,
whole county, employs fewer than
Thank you.
less than 50 employees.
that's what I wanted to hear.
Yep, no problem.
That paragraph doesn't.
And the changes that we've already discussed in making in the policy, for the bereavement policy, include much of this language that she already got in there, so I think this is a duplicate. It's up to you, but,
All right, as long as we have it.
I would say
Excellent.
okay. Alright, so the next one we have is criminal policy regarding consideration of criminal convictions, which it is the policy of Iroquois County to comply with state and federal law in determining the appropriate course of action when an applicant or employee has been convicted of a crime in accordance with the Illinois Human Rights Act unless otherwise authorized by law. Iroquois County shall not use an applicant or employee's conviction record as a bias to refuse to hire, segregate, discharge, discipline, disqualify, or take adverse action against with respect to recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, tenure or terms, privileges, or conditions of employment unless. That's what we're looking at here, which is similar to what we already talked about with the other one.
so. We're already covered.
In my opinion, we are, but that's
Next one,
my opinion. So the next one is, oh, come on, you, discrimination, okay, so this is, wait a minute, sorry, let me make sure I got the right one. My balls aren't working. Notice to ICRMT member entities regarding sexual harassment policy and annual training. Again, I think we already have this one covered. Okay, let's make sure I made notes on it. This refers to our current policy 1054, stating that we are to provide sexual harassment prevention training to all employees on an annual basis. It lists the website that we already use here. Sample policy. And then it does at the last, if I remember correctly. The last page is an acknowledgement and receipt of understanding of policy against discrimination, harassment, and sexual misconduct. This is a little more in depth than the certificate we use, so, I mean, I would not be opposed to using this one other than the certificate that we currently use.
As far as the policy goes, I guess I have an issue about using the word discrimination. What exactly does that entail or mean? It says it says discrimination and then a list and all the things down there, and one of them being age, for example. Well, I can guarantee you that we do discriminate because of age in certain areas. We're not gonna hire somebody for an important position when they're 6 months away from retirement age. By the same token, we may not wanna hire them if we think they're too young for the job. I think age is an important factor in hiring any person. I wouldn't call it discriminatory either, I think it's just one of the things that you consider. Same thing, it goes on to talk about discrimination, talks about a arrest record, conviction record, unfavorable discharge from military service, order of protection.
You have to remember, when you think about, by law, no, you cannot do this, so you have to be a little more creative when you're hiring as to why you choose or not choose an applicant.
I understand what you're saying, but I'm also saying what.
That covers everything right there.
I'm also stating what the facts of life are.
I get that, but our policy handbook can't have a complete listing of facts of life.
We have to recognize the facts of life in our policies, don't we?
Okay, so my question is, can I adopt this last page here with a little more detail instead of the certificate for sexual harassment training? Cause I would like to do that, I like this one. And then is there anything that you would like to change, adopt, add, whatever from their suggested policy into our current policy, which again is 1054?
Comments that I had is what
I mean, unless you specifically, John, wanna put in there a definition of what discrimination is in the policy, I don't know how to answer your question.
Well, the policy at the bottom of the first page defines what harassment is, but I can't find any place where it defines what discrimination is. So I wonder if, on the first page of.
Well, I think it's because this is an actual policy for sexual harassment, it doesn't say anything about discrimination in the title of it, that's just my understanding of it.
The policy title says discrimination, and on the statement of policy, the very first statement says, we will not tolerate or condone discrimination or harassment. And it goes on to talk about it.
Well, do you wanna take the word discrimination out of it?
Well,
That's part of why I'm asking.
we're already covered. Do we even want to do anything other than add the form to what we already have?
If that's the way we want to approach it, that's fine.
Yeah, I
Joe's
agree with
question
you.
is,
Just
do we
use
want
the
to
form.
adopt the policy? That's what
Yeah.
I'm speaking to.
Yeah, I'd like to do that last page, which is fine.
Yeah.
But
I'm
to answer your
speaking to
question,
the other
John,
part.
in our current policy, I understand what you're saying is we do define what, for the purposes the term harassment includes but not necessarily limited to slurs, jokes, or verbal, graphic, or physical conduct relating to an individual's race, color, sex, religion, national origin, sexual orientation, age, physical or mental disability, or marital or veteran status. I understand what your question is, and my question back to you is, do you wanna include a paragraph that describes what discrimination is in our policy? Cause that's what, I think that's where you're getting at, right, is there's not a,
Well, it's either that or taking discrimination out, I think. To me, as I said, I agree that the laws say you can't discriminate, but I'm sure everyone will agree that in actual practice, we do take those things into account. Obviously,
Because
when we
not-
hire somebody or if we're talking about hiring, we're talking about trying to find the best candidate for a job, but the best candidate for a job is one that's gonna be there longer than 6 months or whatever short period of time it might be.
This policy
Unless
isn't,
that pertains to the situation that you
Our
have.
current policy doesn't talk about discrimination, it talks about specifically harassment. So in our current policy, I think we're fine. If you want to adopt this policy, that's what you wanna.
So let's keep the current policy and take that last page that you want. Would that be correct?
That makes
That's
sense
fine
to
with
me.
me,
Yeah.
but yeah,
Yeah, let's do that.
okay.
Next one.
Okie dokie, give me just a second here. Identity protection policy.
actually, our policy to protect social security members.
I think this is in our personnel records policy.
I'm pretty sure that, I don't know if we have this in the policy on this, but I'm pretty sure we do this.
We don't have a specific policy for it, but I think it's covered under our, I'm looking right here, personnel records, policy 1046.
Seems to me it's a rather lengthy thing just to say, not gonna disclose people's social security numbers.
And I think our current policy does a pretty good job of
Yeah, let's just keep going.
including that, it's kept separately and all that.
The other thing is that there are, like it refers to the Illinois Identity Protection Act, there are already laws governing all this, so that we have to abide by.
Right.
I think we leave things the way we got them. Next one,
Yeah, I'm froze.
down to 2 left.
I'm froze. So this is the, wait a minute.
We got these other crazy ones here.
Policy against bullying.
Yeah, there you go.
We need this because of John.
So prohibits bullying in the workplace and will not tolerate it under any circumstances. This policy against bullying applies to all employees, including but not limited to full-time, part-time, contract, temporary, supervisory, or department heads. It also applies to elected and appointed officials and non-employees with whom Iroquois County has a business, service, or professional relationship with. Goes on to give examples, of conduct that could violate the policy, which include addressing an individual in an abusive manner, exclusion or social isolation, personal attack, spreading rumor or innuendo, unreasonable criticism, setting unreasonable demands, sabotage of another's work product, public humiliation, unwelcome touching, any conduct that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interests. Encourage all employees to promptly report any instances of bullying. Employees are not to refrain from participation and encouragement of any contact that would be considered bullying. Supervisors are expected to monitor the workplace for signs of bullying and to take immediate action. Iroquois County promptly investigate all allegations, and employees who have questions regarding this policy may direct them to, please insert name here.
Do we have something like that, bullying in ours?
I don't recall it, but maybe it'd be a good idea.
Okay, so we do, it is actually listed under, let's see here. I'm looking. So staff members. Are prohibited from exhibiting any defamation of character, creating a negative or hostile work environment, harassing or bullying behavior, disparaging comments of race, color, religion, national origin, gender, political affiliation, disability, veteran status, age, or sexual orientation.
I don't think we need this then.
Okay. Alright, what else we got?
So we're not gonna do this one?
You already got something.
Okay,
We don't have a specific policy for it, but we have it embedded in one of our policies. So this is the cannabis drug abuse policy.
Take note of this, Charlie.
So,
Alcohol,
Stop it.
right?
This one is for Charlie, you said?
That's why I got a son that's a doctorate looking for
so this
protection. That's-
goes through, gives you background on Cannabis Regulation and Tax Act, the Compassionate Use of Medical Cannabis Program Act, the Right to Privacy in a Workplace Act. The intent is concerned about ultimate effects of the use of cannabis, alcohol, and illegal drugs used upon the health and safety of its employees and the public. We recognize that studies show that alcohol and drug abuse leads to increased accidents and medical claims. Also recognize state legislation has accepted that modern medical research confirms the beneficial uses of cannabis in treating and alleviating pain, nausea, and other symptoms associated with a variety of debilitating medical conditions. Goes through a list of definitions such as premises, on-call, illegal drug, cannabis, CBD, substance, traceable, reasonable suspicion underneath a lot of definitions.
This is a policy that we need because of the law that was just recently put in effect, is that what we're saying?
I'm looking to see what our current policy.
I don't think we have anything specifically.
I don't think we go into that much detail because basically each bargaining unit is gonna have different expectations of their policy. Give me just a second, I have to look into that.
The bargaining union contract supersedes this.
I know.
Well, sure it does cover everything.
Mr. Raymond?
Didn't the county take a position of a drug-free? I don't think it was necessarily put as part of the policy and procedure manual, but I believe the county has the position of a drug-free employer.
That's listed in a different one here, I think. There's something in here about it anyway.
I also recall having a very lengthy conversation regarding it with, it wasn't ICRMT, it was the previous insurance provider. That there was a lot in conjunction with the law and the way that it was, that pretty much if they were using, for example, marijuana on company property, that was a different situation than if they were using it in the comfort of their own home.
Very slowly here.
Yeah, this does not allow you to use it on anywhere here, and it also talks about if I can find it. Employees may not report to work beyond the Iroquois County premises or in Iroquois County time under the influence of alcohol or cannabis with any traceable illegal drug or substance in their system.
So if it's covered in there, maybe worthwhile to have a conversation with ICRMT to how, if somebody does arrive to work with, under the influence, I mean, alcohol's got its better opportunities for us to figure that out, but when we're talking about cannabis, for example, what methods and modes can we use?
It's all covered in here.
It doesn't, okay.
And still getting to our policy, just taking forever.
Seems to me, I don't know, I think it is a rather lengthy one, but it seems to me it's something we probably need to have. What do you think, Lyle?
Well, depends on what we already have. I mean,
Yeah, I'm looking, it just gives me.
When it was done last year. When was it amended? I'm sure it's changed again.
I would say that
Smarter than me, I
just
should
a
just
lot
brought my
more
paper copy.
specific and a lot more detail, and it probably is what we probably need to have.
so
What we have
Okay,
right
so
now
we
is
do have
more of a
policy
general thing.
1055, which is the smoking and tobacco use, but this is different. And then the next policy is going to be policy 1056, nope, that's wrong.
1057.
What we have
7,
now,
give me
what
1 second.
we have now, for example, says an employee must report to work in an appropriate manner.
Okay,
This
so
is- you can't have any trace of alcohol or drugs, that's a big difference.
our current policy is 1057, which is substance, alcohol, and drug abuse. The purpose of this policy is to set the standard for a drug-free, healthy, and safe workplace. The policy is that Iroquois County's desire to provide a drug-free, healthy, and safe workplace. To promote this goal, employees are required to report to work in appropriate mental and physical condition to perform their jobs in a satisfactory manner. While conducting Iroquois County business-related activities, no employee may use, possess, distribute, sell, or be under the influence of alcohol or illegal drugs. This policy also applies to all official or unofficial breaks and meal periods and all other times in which the employee has reported for work. The only exception to this policy is the responsible use of alcohol at official county-sponsored social or business events at which alcoholic beverages are served. The legal use of prescription drugs is prohibited on the job only if it does not impair an employee's ability to perform the essential functions of the job effectively and in a safe manner that does not endanger other individuals in the workplace. The employer reserves the right to require drug testing for cause or reasonable suspicion of being under the influence. Reasonable suspicion includes, but is not limited to, the employee appears confused or exhibits erratic behavior, the employee has difficulty getting along with other employees, the employee exhibits paranoia, slurred speech, or irrational behavior, the employee has had a single or a series of safety-related incidents that raise questions about his or her physical and or emotional state. Employees who refuse testing when reasonable suspicion is present will be subject to discipline up to and including termination. Violation of this policy will lead to disciplinary action up to and including immediate termination of employment, or if the incident is a self-reported, required participation in a substance abuse rehabilitation or treatment program. Such violations may also have legal consequences. Employees with questions of this policy or issues related to drug or alcohol use in the workplace should raise their concerns with their department head or supervisor without fear of reprisal. And it goes through, it is a responsibility of the employee to report to work. The department head or supervisor to observe the employees, and the responsibility of employees to notify them of if a fellow employee is also exhibiting signs. The procedures will be to notify department head or supervisor. Then they would meet with the employee, the department head or supervisor would determine if and where the testing is to occur, and arrangements shall be made to have the employee driven to the testing and home pending the results of testing. If the results are negative, the employee will be allowed to return to work at the next normal shift. Let me keep going. Any drug and or alcohol testing required or requested by Iroquois County will be conducted by a laboratory licensed by the state. The employee may obtain the name and location of the laboratory that will analyze the employee's test sample by calling the county board office. If an employee is asked to submit a drug or alcohol test, the county will notify the employee of the result within 3 business days after it receives them from the laboratory. To preserve the confidentiality, the county strives to maintain the employee that will be notified whether to test the negative or confirm positive, and if confirmed positive, what the next step is. If the employee receives notice that the test results were confirmed positive, the employee will be given the opportunity to explain In addition, the employee may have the same sample retested at a laboratory of their choice. The county will pay the cost of drug and alcohol testing that it requires or requests employees or applicants to submit to, including retesting or confirmed positive results. Any additional tests that the employee requests will be paid for by the employee. That's what's currently in our policy.
Would you like to read that again?
Thank you.
Since I wasn't here. I won't do that to you.
Running short on time.
Only for you.
I'm teasing her.
Only for you.
So do you wanna keep what we have, or do you wanna adopt this?
I think this, to me, shows it's more in depth. Is this more in depth for you?
Covers all your habits.
Covers it up.
So which,
I almost
which
like
do you
theirs
want? I don't know. Which do you want?
I would like this one.
Okay, so put it over here, that's the new one.
Go right past that.
Yeah, what's the next one, Joe?
We're gonna go with the new one.
Yeah, I kinda like how theirs is.
Yeah, I like
Let's go to the next one.
Okay, so the next one is the whistleblower policy. Looks like this. And it is our current policy 1064. So their policy gives a summary of the law, where our policy just refers to it. It doesn't give a summary.
It says here, and I guess this is something that we have never done, but maybe something we need to adopt. It says that the law says we have to give every employee a copy of our policy once every year. So whether we adopt this policy or the one we have, this is something that we apparently are not doing. Not really sure why the law says that, other than it seems to me that just encourages whistleblowing. Maybe that's a good thing, I don't know, I'm not gonna say whether it is or isn't, but it just seems to me that it encourages it.
There's a lot of things that must be done once a year, you know, for safety reasons, and so this is just something that it makes it easier for the employee to have it, because in a year's time you can lose it.
I'm just saying, something we're not doing. Correct me if I'm wrong.
You might be refreshing their memory too.
We adopt this one, then we also have to give them a written summary of a completed copy of the act once a year.
We don't have anything like this right now.
We do. We have a whistleblowing policy 1064. Is our current policy. So our current policy states that the county will protect employees who report in good faith what they reasonably believe to be a violation of state or federal law, or conditions or practices that would put the health or safety of employees at risk. Our policy states that employees are expected to first report the alleged violation, condition, or practice to a person with supervisory authority over the employee, and to give county time to remedy the situation. The problem resolution process is available for this purpose. No employees will be discharged, threatened, or discriminated against in any manner for reporting what they perceive to be wrongdoing. Examples of kinds of activities in which employees have the right to participate in without being subject to disciplinary action and harassment include, but are not limited to, filing discrimination charges with the Equal Employment Opportunity Commission or State Human Rights Agency, filing unfair labor practice charges with the Public Labor Relations Board or state agency, filing a workers' compensation claim, filing a complaint with Occupational Safety and Health Administration about safety hazards, or refusing an assignment because of fear that it might be dangerous, engaging in lawful union activities, claiming an equal pay or wage hour law violation, opposing or publicizing policies that violate laws such as Equal Pay Act, antitrust protection, or fraudulent tax returns, reporting fraud, corruption, or other forms of law breaking covered by the Racketeering and Corruption Organization Act, the Sarbanes-Oxley Act, the Whistleblowing Protection Act of 1989, or state whistleblower statutes. That goes through our responsibilities and our procedure.
I'd like to suggest that we send this to the state's attorney and get his recommendation on it.
Okay.
Next one.
Alright, next one is school visitation leave policy. So, school visitation leave policy looks like what I have on the screen. In accordance with School Visitation Rights Act, an employee who has worked for an employer for at least 6 consecutive months and works at least half-time schedule may take up to 8 hours off during any school year and no more than 4 hours in one day to attend school conferences, behavioral meetings, or academic meetings related to an employee's child, provided that the conference or meeting cannot be scheduled during non-work hours. Before taking leave pursuant to this policy, an employee must have exhausted all accrued vacation leave, personnel leave, compensation leave, and other leave that may be granted to the employee except for sick leave and disability. Employees who intend to take leave pursuant to this policy are required to provide a written request at least 7 days. Emergency situation, 24 hours.
Do we have anything like this now?
I don't know.
For the most part, aren't
I mean, I think it
Aren't
rings a
leave
bell that we had
policies-
something in there about school leave.
aren't leave policies mostly left up to the department heads?
46. Yes, but we do have a policy, Illinois School Visitation Rights Act policy.
I mean,
yes, but we have to have something to go by as far as if you're gonna discipline someone for something or.
Yeah, and we do have a policy, it just takes me a minute to get to it. Do you have a paper copy of ours?
I do.
I just wanna know how it's different than this, if there's
Alright, so our
anything-
current policy is the Illinois School Visitation Rights Act, which is 1022. Basically goes through the purpose, which is the same, to provide employee parents and guardians to,
They both say the same thing with it.
yeah.
Let's go with what we
Private
have.
schools. Yeah, increments no less than 1
Let's
hour,
go to the next
4
one.
hours must be, only our policy says 4 days, whereas this policy says 7 days. Notice,
We're following whatever the state law says, so that's,
yeah, I think ours is good. Ours actually goes into a little bit.
let's go with what we have.
Okay,
Next one.
next one is travel reimbursement policy, which,
We already did that one.
wage and salary policy. So.
Do we have one now?
No,
Most of your bargaining agreements should already have this covered as
We
their
don't.
exception.
I
we
have-
don't,
I have two comments about
we
about
don't
this.
necessarily have one like specifically for wage and salary policy, they're trying to just, they're worked into several different policies, if that makes sense.
I have two, if we want to adopt this, I have two comments about it.
Mhm.
At the bottom of the second page, there's a spelling error, it says please not, it should be please move. And the last sentence in that same paragraph says, I cannot quite understand this, if I believe what it says, it can't be right. Just however, an exempt employee's salary will not be reduced for partial day absences if he or she does not have accrued paid time off. The sentence before that says you use accrued vacation, personal or other forms of paid time off when you're absent for this. Now, you don't have any of that, you still get your salary. That doesn't make sense.
I would choose to not adopt this because we have specific policies that refer to, you know, deductions or what a employee's leave is, and our policies are a little more spelled out how they would fit our payroll. This kind of takes all of it and cramps it together. But that's just my opinion, I mean, I don't
It doesn't,
necessarily.
you know, a lot of this stuff, our system works, but do we need, and we're just trying to clarify it.
I mean, the
black
sample
and white, and
policy,
make sure everybody understands it, so.
just so everybody else in the room can see, I mean, the sample policy goes through, you know, the vacation, personal, and we have specific policies for each one of those, so I don't know, that's just my
What's the
opinion.
next one? We're running short on time here.
I'm going as quickly as I can, right? Alright, let's see here, reasonable accommodations, which I know we spent time on ours about, but this is our current policy 1002. Their recommendation policy pretty much covers what we have.
Yep.
Directed to your supervisor, all that goodness in
Above
there,
all else, we always want to be reasonable.
that's what they'll
Whatever
tell
that
you
means.
anyways, right?
Right.
Alright, so social media policy and guidelines. Is our current policy 1068, but the sample policy goes through. Is the official policy for social media use, so theirs goes through professional use of social media. Once authorized, you must disclose that you are an employee, elected official, disclose and comment only on non-confidential information. Personal use recognizes that you may use social media in your own personal life. It does not intend to discourage or unduly limit your personal expression. However, you should recognize that the potential for damage caused either directly or indirectly in circumstances via your personal use of social media when you can be identified as an employee or employer.
Is this something that is gonna be influenced by our decision to have a Facebook page, and maybe we should?
We already have a policy in place, so it's policy 1068, and I think after looking at ours and with this one, it's pretty similar to what ours is.
But that's gonna cover with our Facebook page as well then, I mean, that's not something we're gonna need to modify because of that.
I mean, I would
Are we
assume,
good?
yeah, I would
We're
assume so. So, I mean, as long as you abide by our policy that we already have in place, yeah, I would assume you're good.
Okay, well, I'm just asking a question.
You can do that.
Just confuse me.
I asked
Okay.
a lot of questions, I don't know about the answers.
I just read it to. Okay, Avesta policy, and this is the last one. Victims' economic security and safety, the Avesta policy is our current, we do have a current policy here. Which is our leave Vesta policy 1035, so. The only thing is it was amended in January of 2022 to provide benefits and protections to the victims of crime of violence, which is defined to generally include crimes such as homicide, sex offenses, bodily harm, harassing or obscene communication, terrorism, and armed violence. But I think if I remember correctly, we just list the apps and we can change it.
So I can cover you, always tell me, do I have them there?
Only-
More harass me for
This
that.
is all reasonable.
Right.
Okay,
Alright,
so,
So we're not gonna use it? We're done with it?
Just gonna use or keep our current policy.
Yeah.
we got two of them that we're sending to the state attorney.
Got it.
The rest of them are kaput. Right?
Some we're using. Some of them we are using.
Which one?
We're gonna adopt
She's done.
one of them, and then I'm gonna use the last page. We're sending the whistleblower policy to Mr. Devine.
The Garrity one.
The cannabis, drug, and alcohol use, we're gonna incorporate that, because it's a little more detailed than ours.
Yep.
And then, I'm gonna use the last page for the central, instead of the certificate, have to fill out this one. I'm gonna start that next year. This year, we're just gonna do certificate. And then the other one we're sending to Jim was the,
Guarantee.
Okay, moving on, we're not going to executive session, appointments will be made at the board meeting. We do have a little bit of correspondence that I will pass around. Friends at Show Bus want us to give them some money, we never have in the past, I do not recommend that we give them any money now.
Why?
Set that down there.
Why not? Why not? I have a question.
We never have before,
So?
we're not gonna start now,
We don't have any money to give.
that's another
Well,
reason. That's another good reason. If you wanna give them money out of your own personal funds, you're entitled to do that.
You gotta go to that.
Also, for purposes of knowledge, I will tell you that I have been sued.
Oh,
I will pass the letter along to you so you will
again?
can understand what that's all about. The sheriff has also been sued for the same thing.
That's going that way.
troublemakers.
Yeah, so why are you suing it?
On the record, I am not
You're not what?
suing you.
At this time.
Pass this one. And then there's a letter, a rather lengthy two-page letter saying, expressing to Tom Latham that his plan has been approved for the coming years. That's end of it there. We have some claims this morning. Everybody should have had a chance to see the claims. So I will entertain a motion to approve those claims.
For, I don't understand it.
Mr. Ducat, do we have a second?
Second.
Mr. Barnes, would you call the roll, please, Amanda?
Dugat, Barons,
Yes.
Yes.
Awful,
Yes.
sure.
Yes. Is there any old business to come before the committee this morning?
Oh, yeah.
Under old business, I would just remind the committee that next month we will again be planning to conduct a final interview with Danielle Ballmer for the assessment position.
What position?
Supervisor of assessments. We interviewed her last month and we indicated we would interview her again at our May meeting, so that's our next meeting, so everybody's aware of that. Is there any new business to come before the committee? If not, do we have a motion to adjourn?
So moved.
Mr. Law, is there a second?
Second.
Mrs. Awful, all in favor say aye.
Aye.
Opposed, same sign, meeting is adjourned.